Welcome to the third edition of my series Data Protection Law in Europe, which I made for on behalf of the Faculty of Law in Stellenbosch. I want to speak today about a problem I have mentioned already in the second part of the series. I mentioned in the second part that the GDPR, the European Data Protection Regulation, applies not only to European companies, but according to Article 3, as well to foreign companies, for instance, which have their seat in South Africa. The extraterritorial use of the GDPR depends on the questions whether a South African company markets its goods and services to European citizens, for instance, via internet. But if a South African company does market and offer its good to European citizens, the GDPR applies. But that is not the only way how South African companies can be bound by the GDPR, and that will be explained in the third part of the series. I will now explain to you the regulations on data export and data protection supervision. That are the rules for the transfer of personal data abroad, so outside the European Union, the effect of safe harbor and privacy shields, and I will explain the obligations and supervision structures of controllers. Article 44 and following of the GDPR applies to the transfer of personal data abroad. So, you have to understand, if you transfer data within Europe, it's free. So, there is no special regulation only because one party of the transfer is situated in Belgium or in Spain or whatever. So there's no distinction between transfers within a state and between different member states. So that's the idea of the European Union as being a place where all data can circulate freely. So it's prohibited for a European state to build up a kind of protection shield specific in data protection. But on the other hand, the transfer of data to non-member states, so-called third countries, including South Africa or the United States, is only permitted under the conditions of Article 44. That seems to be a contradiction, because on the one hand, Article 3 said we have an extraterritorial use of the GDPR, which is applicable to, for instance, US companies. But in addition, these American companies are bound by Article 44, so that seems to be a contradiction. Data may only be transferred if the Commission determines that the third country offers an adequate level of protection. That is a very, very harsh word, adequate level of protection. The United States, for instance, doesn't have a level, doesn't have a protection, and doesn't have adequateness. So the transfer of data to the United States is totally prohibited and is regarded as a big problem by European authorities. How do we define adequacy? So it is determined on a state-to-state basis, so the Commission checks carefully what is the rule of law, how are human rights and fundamental freedoms guaranteed, what is in the legislation as to national security, how are data protection laws defined, what are the rights and the remedies of data subjects, how is supervision, an efficient supervision of data protection guaranteed, and does the state have specific international data protection agreements. I don't think that South Africa has a certificate by the European Commission that South Africa has an adequate level of protection. So that might be a problem to send data to South Africa. If South Africa has met the criteria, the transfer of personal data to South Africa is permitted as if South Africa were an EU member state. So if you cannot prove that you have a transfer of in a country with an adequate level of protection, then you have to provide for specific guarantees, and that's very harsh to establish. You don't need to prove an adequate level of protection in specific cases. For instance, if the data subject expressly has consented to the transfer, for instance, a German tourist wants to go to South Africa and the travel agency asks the data subject for consent for the transfer to South Africa. For if the transfer is necessary for performing a contract with the data subject, again the travel agency wants to prepare a tour in South Africa, then it's allowed to transfer the data. The biggest problem in this moment is USA. As I said, USA doesn't have an adequate level of protection. An adequate level of protection, for instance, has Brasilia, Japan, South Korea, Switzerland. Only a few states have an express certificate of the European Commission regarding its level of protection. So the European Commission started several years ago negotiations with the United States. They called it Safe Harbor. That means the American companies could show a certificate on their products and services saying we can guarantee that we as a company provide for safe harbor regarding European data. But that exists, the safe harbor idea, but then there was a strange guy, I like him very much, he's called Maximilian Schrems from Austria. He sued against Facebook and said safe harbor is bullshit, because nobody's really taking care whether a company provides safe harbor. So it's not adequate simply to say on your product we can provide safe harbor. There's no proof of safe harbor. So he went to the European Court of Justice, and the European Court of Justice said you are right and declared invalid the model of safe harbor. Then the European Commission and the US government started a new round of negotiations, and they invented a new tool, so-called Privacy Shield, that was better than safe harbor. But again, there was Mr. Schrems who started a new proceeding in front of the European Court of Justice, and the European Court of Justice almost 1 year ago said, yeah, you might be right. Even the Privacy Shield doesn't work. It's not enough, it's invalid. The only way to transfer data to the United States is an agreement, so-called model agreement, provided for by the European Commission. That can be used, and these model agreements were old, but they can be used. But the person sending data and the US company receiving data must prove that there is effective technical protection for these data. Of course, this decision was highly influenced by the problem of Snowden, Edward Snowden, living in Russia under harsh circumstances, being responsible for whistleblowing and showing that US security people took advantage of even European data. So the court said, having Snowden in mind, the US is so bad, you can use the old model agreement, but you need additional technical measures to protect European data. To tell you that, again, the European Commission and the US government started negotiations for the third time, and the European Commission has published in June this year new model agreements, and you have to use these new model agreements, otherwise you are killed. So please have a look at the homepage of the European Commission. Check very carefully which model agreement can be used and integrate it in your cooperation with Europe. So the controller has to prove that he is compliant with the requirements. You have to have technical precautions for data protection, and you have to realize the principles of transparency and information obligations regarding the person concerned. If you make a mistake, and that applies to South African companies as well, you can get sued and you are obliged to pay high damages and even sanctions, for instance, fines up to 20 million euros. That is a high loss for a South African company. Who is responsible for these fines? The fines are prosecuted by the supervision authority, so every state has its own supervision authority, and there is above a European supervision authority. So they have a lot of powers to investigate, correct and advise. They are independent and they are monitoring the application of the regulation. Each member state shall provide for each member of their supervisory authority to be appointed by means of a transparent procedure by their parliament, government or head of state, and you need to be qualified, and you see that's a high danger to be to get contact with the supervision authorities in the member states and on a European level. So please be aware what is happening in South Africa if you are cooperating with a European data processor and involving European data. That's a really big threat to get fined, be obliged to pay high damages. So that's all for session 3, and I try to finish this series with a 4th video which will follow. Thank you for listening.